Hey everyone, Lee Pacchia here from Mimesis Law. I'm joined now by Professor Robert Blecker at New York Law School. Good to see you again. Thanks for stopping by.
Thanks for having me again.
So you are traditionally, or you've been traditionally known as a criminal law professor, but you're kind of returning to your original roots going into sports and philosophy. You've done some really interesting research into the government's prosecution of baseball player Barry Bonds over allegations that he used performance-enhancing drugs, particularly at the end of his career. What prompted this inquiry?
Well, the recent argument before the Ninth Circuit brought it back again in focus, but I'm interested in what the government's done and what Bonds did and whether this is all an appropriate reaction and way of handling it, because it strikes me that what's going on now in his prosecution and in his appeal of the prosecution is a make-up call. That is, the public assumes that Bonds was prosecuted and convicted for perjury when he said that he never used performance-enhancing drugs, which he almost certainly did, at least the public believes he did, but a jury didn't convict him on perjury. They hung on that issue. They couldn't get a unanimous conviction. And so I think the government, to try to make up for what they thought was a bad jury call, went after him for obstruction of justice on the basis of a single statement that he gave when he was asked under oath, having sworn to tell the truth, the whole truth, and nothing but the truth, whether he had used steroids. Bonds said initially, "You don't know what it's like to grow up as the son of a famous father." And he went off into a 20 or 30...
Basically just didn't answer the question.
That's right. It was an unresponsive but arguably true statement. And it alerted the government that it was unresponsive, and so they pressed and they pried and they probed and said, no, we're not asking about what it's like to be the son of a famous father. We're asking what it's like we're asking whether you used steroids. Now, that's really interesting because the case that on appeal that both the defense and the prosecution cited and hammered away at was Bronston, which is the leading case coming out of the United States Supreme Court. It's the same case, by the way, that President Clinton used and hammered away at to defend himself when he allowed his lawyer to say, as you know, there is no sexual relationship between my client and Ms. Lewinsky. And Clinton later defended the truthfulness of that, saying, well, if is means is and never has been, well, then no, that was a false statement. But if is literally means is at this moment, there is none.
Right.
And when he said, I was never alone in the Oval Office with Ms. Lewinsky, he used Bronston and said, well, the Oval Office can be understood as the whole Oval Office complex, and Betty Curry was always in an office down the hall. So what
How
happened?
strong a legal concept is Bronston? Did the court get it right?
Well, no, the court got it wrong. Here's what happened in Bronston. Samuel Bronston, who was a major movie mogul, went bankrupt, which I understand given some of the movies that I've seen that he produced. And in the bankruptcy proceeding, which was called to locate his assets for the benefit of creditors, he was asked under oath, Mr. Bronston, do you have any Swiss bank accounts? Answer, no. Have you ever? Well, the company had an account for a while in Zurich. The fact was the company did have an account for a while in Zurich, but so did he personally. And so the question was that perjury? The company did. It was clearly deceptive. It was clearly misleading. And then the question was, but was it false? Well, he said the company did have an account, and the company did have an account. And a jury said that that was perjury because it was a lie in context. It wasn't the whole, he swore to tell the truth, the whole truth, and nothing but the truth. And that was a half-truth. And if it's a half-truth, what's the other half?
Right.
It's got to be false.
Right.
And so this comes up in terms of what is the appropriate standard of truth. By the way, this also comes up in my view in terms of what's the appropriate standard for referees and umpires. Do you only call something in isolation that's literally so, or if you've done a bad call, is it ever appropriate to engage in a make-up call, which is what the government apparently thought was appropriate in this case. And I won't go off into that now, but just to stay with truth and Bonds, although I think that's lurking underneath about make-up calls. I think the government thought they were engaging in a legitimate make-up call and they were wrong. So anyway, it went up to the United States Supreme Court after a jury convicted him of perjury, and the United States Supreme Court unanimously reversed his conviction, saying the person who did wrong was not Bronston. It was the prosecutor for not pressing and prying and probing for this obviously unresponsive statement. But I disagree with you, Lee, because yes, it is their job. When it's an obviously unresponsive statement. That wasn't an obviously unresponsive statement. Do you have any Swiss bank accounts? No. Have you ever? The company did. Well, an unresponsive statement would be, have you ever? My daughter likes spaghetti.
But how do you tell the difference? Yeah, well, there you go. How do you tell the difference between a brain fart on the stand and an active, misdirection
What-
or fraud or malfeasance.
Well, it goes to the culpable mental state, which is required, by the way, for obstruction. He must have corruptly done it. That's another problem with bonds.
Sure, this is testimony, though. It's in court. You know, someone's on the stand.
The company did is clearly,
Yeah.
as the Second Circuit
closer.
said, in affirming his conviction.
Yeah.
There's no reason for him to say the company did unless he wants to falsely
Sure.
imply, but I personally did not. But the bankruptcy in the Bronston Standard is that the United States Supreme Court held that as long as the statement was true in isolation, literally true, it could not be perjury. But even if that's so, it could have been and should have been obstruction. Whereas bonds is just the opposite. Here, the defense is claiming, using Bronston, again, as long as his statements were literally true about being the son of a famous father, it could not be obstruction. That's wrong. It can and should be, but only if it's deceptively so. But his responses weren't deceptive. They immediately led the government to follow up. Mr. Bonds, we're not asking you about what it was like to be the son of a famous father. We're asking, did you ever use steroids? And he said no. He didn't. Now, it was up to the jury to convict him and up to the government to successfully prosecute him for perjury, and they failed to do it. But to use that as obstruction of justice and to cite Bronston is wrong. So in my view, both sides are wrong. You can be convicted properly of obstruction of justice for a statement which is true as long as it's consciously calculated to deceive. So the defense is wrong there. But the government is wrong. You should not be able to be convicted of obstruction of justice for a statement that is not deceptive, even though it does temporarily derail the inquiry. So both sides are wrong. But the Ninth Circuit, in my view, made it perfectly clear that this was a makeup call that they weren't going to embrace.
Right. So it's game time for you, Professor Blecker. What's the court going to do on this appeal? How do you see it coming down?
I predict that the court is going to reverse the conviction. And if they affirm the conviction, and probably even if they reverse it, it will go up to the United States Supreme Court.
Right, that's where I was going to go. How do you think the Supreme Court is going to treat this issue?
Well, they might strike it down narrowly as not qualifying under the obstruction statute because no proof of corrupt intent. But if they do, as I hope they will do, but predict they won't, if they use this case as the occasion to revisit and reverse their bankrupt Bronston standard of truth and substitute instead contextual truth and pragmatic truth that puts the listener into working touch with reality, then whether or not Barry Bonds makes it into the Hall of Fame, he will deserve it to make it into the legal Hall of Fame.
Really, really fascinating stuff. Professor, thanks so much for stopping by and taking us through this.
Thanks for having me.
That's Professor Robert Blecker from New York Law School. If you'd like to see more of the stuff they're working on here, be sure to go check them out at nyls.edu. I'm Lee Pacchia. See you next time.